your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, and licensed immigration attorneys engage, learn, and stay informed on the latest developments in U.S. immigration. My name is Nikita Bahadur, and I'll be your host for today's session. Asylum policy changes and expedited removal proceedings under the Trump administration. Asylum seekers today are facing some of the most significant changes in years. New rules, expanded enforcement, and accelerated timelines have reshaped how cases are handled. For many individuals, these changes can mean the difference between protection and sudden removal. Understanding your rights is essential, especially in an environment where decisions are made quickly and procedures are increasingly strict. To help us break down these changes, we are joined today by attorney Vilerka Bilbao, founder and CEO of Bilbao Law LLC, a firm focused on defending immigrants and human rights. Attorney Bilbao has been licensed in the Northern and Southern Florida District Courts since 2018 and has worked with nonprofits while providing pro bono representation to families separated at the border. Her experience gives her valuable insight into how asylum policies operate in real-world cases. You're welcome, Attorney Bilbao, and thank you so much for joining us today.
Hi, Nikita. Thank you for having me.
Before we begin, a quick reminder, immigrationquestion.com is not a law firm and does not provide legal advice, representation, or services. This platform serves as a public meeting ground where individuals can learn about immigration topics and engage with independent licensed attorneys. To our viewers tuning in from Facebook, YouTube, LinkedIn, and other platforms, welcome. If you have not subscribed yet, now is a great time. Go ahead and hit that subscribe button. Grab your notepads and let's get straight into today's discussion. Attorney Bilbao, what are the most significant asylum policy changes implemented under the Trump administration, and how have they altered the process to new applicants?
Thank you, Nikita. There are a lot of policy changes in asylum, and if you are an asylum seeker right now, your head might be exploding trying to keep up with all the changes. So I'm going to go through some of the most sort of general ones, but it's important that if you are working on an asylum case to make sure that you are paired up with an attorney, especially when working in asylum. I always tell clients they should be working with someone who speaks their language and ideally from their country to do their asylum case. And that's because that person can understand and has better access to the information that's coming out of your country than someone who doesn't speak your language at all, who doesn't understand your culture at all. So that's one thing for asylum seekers. Now, one of the big changes has been for people in the Northern Triangle, so El Salvador, Guatemala, and Honduras, is these new things called Asylum Cooperative Agreements, ACAs. Basically, the United States position right now is that those three countries are safe countries to return to, and those three countries have an asylum process themselves. So if you are from one of those three countries, or from Central America, they are pressuring you or asking to go to one of these three countries to seek asylum there. Now, I haven't seen it in court yet, where a judge basically closes someone's case out and transfers them to this other country's asylum process. But that is the expectation, that people are going to be pushed to these third countries to be able to process their asylum claims there, especially for the people who are maybe from South America or Central America and traveled through those countries. So if you do have any connections to those three, El Salvador, Guatemala, and Honduras, you should be looking out for that, because there might be a push of the government trying to push your case to be processed there. Another big recent change is basically right now there are no claims for people who are seeking asylum based on their gender, or based on family-based cases. So I'm having persecution based on my family relationship. I'm part of, this family group, and my persecution is due to that. During the first Trump administration, there were also limitations on that. The cases were called Matter of AB, and there's several ones that went up to several. There's like Matter of AB1, Matter of AB2, Matter of AB3, and then they came down. That's why I'm saying some of this is sort of like a headache, because you don't know which one is valid and when it's valid. But basically, if you are an asylum seeker and you're saying that your persecution is based on your gender, either because you're a woman or because you're a man or because of your family base, those cases are going to be limited in getting relief right now. So, for example, if that is one of your cases, you probably don't want to push for a trial right now. Or if you're in front of USCIS, you probably don't want to ask, hey, can I get my asylum appointment right now? Because you're probably going to end up losing. Now, that doesn't mean that you don't fight your case, and I'm going to talk about that in a little bit. But it just means that you're probably not going to get the relief that you want at this stage. You might have to appeal to be able to get that. Another big limitation is gang-related asylum cases and crime-related asylum cases. So there is generally this idea that if you have a private actor harming you, you could still apply for asylum. There's case law that allows you to do that, as long as you can prove that your country is still unwilling or unable to protect you. So a good example is, let's say the cartels are coming after my family, they're coming after my land, they burned down our house, they're not letting us live. The Mexican authorities are not doing anything about it. I came to the United States seeking asylum. That traditionally has been an asylum that could be winnable. If you can prove that your government is unwilling or unable to protect you, especially when the government is colluded in the crime, which often happens in some of these countries. But recent case law that has come out is basically making it really hard for people to win those sort of asylum claims. So with that, whether it's a gender-based claim, a family-based claim, gang-related, crime-related asylum, you really need to be documenting not only your harms, not only the attempts that you tried to get protection in your own country, but also what your government is doing. So a lot of people, especially when they're doing asylum by themselves, they focus on proving only what happened to them. This is what happened to me. Here's my police report. Here are the harms that happened to me. But they don't necessarily prove that their government is somehow colluded or somehow participant in all of this crime. And so having country conditions, lots of them, not just one or two, as in reports, we hire, for example, expert witnesses. So people who are experts in your country conditions and what's happening in your country. All those things can make the difference, can make or break your case. And then the other thing is understanding that an immigration judge's decision is not a final decision. So you do have a right to appeal any immigration judge's decision that says, no, I don't want to give you any protection, no asylum. You appeal that to the BIA, which is the Board of Immigration Appeals. You have 30 days to do so, and you cannot be late, not even by an hour. So if you are filing that BIA appeal, you need to do it immediately. With my clients, for example, we have the discussion of appeal before we go to trial. Because if you appeal, you are able to stay in the United States while that appeal is pending, maintain your work permit under your asylum, while that case is pending. So there are benefits to appealing the case. You don't have to leave the United States right away. And the appeal form is relatively easy to fill out. And it's saying the immigration judge made a mistake in all of these things, or the ruling of the judge goes against what asylum law actually is, even though this is the current policy of this administration. However, what's really important to know is that after you file that appeal, the EOIR 27, which is the basic form to file the appeal within that 30-day, you are going to get a briefing schedule where you're going to have to make long written arguments to the court about why your appeal should be overturned. In your case, you should win your case. So those things you should always work with an attorney to do, especially because whatever comes out of the BIA could potentially be law for other people coming behind you. So we want to always make sure that we're pushing good law towards that. But understanding that you have a right to do that, and that whatever an immigration judge says about your asylum is not final. The other thing about the BIA is, let's say the BIA denies your appeal in 2, 3, 4 years, whenever it comes out, you have a right to go to your federal circuit. I'm in Florida, so that's the 11th Circuit. So that's where we filed those appeals. So again, the decision of the BIA on your asylum is also not final. It's not the ideal position to be in, because obviously asylum seekers, we want to have a decision as to where your family is going to be, where you're setting down roots. But it is not a final decision, right, up until you get to that circuit court decision. So there's lots of ways to protect yourself in asylum, even if the law right now is not in your favor. A couple of other changes, because there's a lot in this, is that there are deportation and removals to third countries. So you can, when you apply for asylum, you basically apply for 2 other things at the same time. One is called withholding of removal, and the other thing is called the protection under the Convention Against Torture. Most people are applying for all 3 at the same time. Sometimes you don't win asylum, but you win one of those 2 sort of sub benefits. And the reason why benefits is because you can never get a green card through them. They'll allow you to stay here in the United States with a work permit, but you can never do the next step to apply for a green card. The government now, even if you win on those bases, is pressuring people to go to a third country to be removed. So let's say that you did win your case and you won withholding of removal. You proved that the government couldn't deport you back to Cuba, let's say, because Cuba would torture you if you go back. Well, now the government's going to pressure you to go back to Panama or to go back to Mexico, because these countries are accepting immigrants. So it's really important to try and fight to win the asylum case, because that is the one where the government should not be sending you to a third country. There's some other changes that are happening that don't necessarily have to do with the law, but one big thing that's happening is pre-termination of asylum claims. So a judge can look at your case. Let's say that your case has been pending in court for 2 or 3 years, and all you have submitted to the court is your I-589 asylum form. And maybe it's not filled out with the most detail. Maybe it says, look at my declaration, or no, or, it has very minimal information. A judge is allowed to pre-termit, basically saying, we are not going to see this asylum claim. This is not a viable claim. There's nothing here, and close your case out without giving you that trial date. So there's a lot of people getting notices in the mail, either to update their asylum case immediately, maybe with a very short timeline, or that their case is being canceled completely. And that means that there's no testimony from the client in the file, usually. You got to be very careful when you're filing your asylum claim, and when you're filing that I-589 form, to give as much information as possible. As attorneys, we usually file the I-589 with a detailed summary of what the person's claim is, but we don't file the case really up until we have a trial date, because a trial could be 4 or 5 years away from now. So if we prepare something now and the law changes, then we have to charge the client again to go to trial, right? So in general, the practice has been to just fill out the form completely with enough detail. But if you have been working without an attorney, make sure that you're revising your I-589 so you don't get one of these notices that your asylum is no longer valid. There's also a new asylum fee people are getting notices for this. If you don't pay the $100 asylum fee, your case is going to be dismissed eventually. So that's something new that asylum seekers didn't have to do. There's also going to be a yearly fee. The court doesn't even have instructions on how to pay that yet, but they're supposed to be, for every year that your case has been pending, you're going to have to pay another $100. So people who have pending cases that have been pending for 8 or 9 years, it's unclear whether they're going to have to pay only the filing fee or whether they're going to have to pay those 8 or 9 years pending. I'll let you know. Not even the judges right now know what to do with those. Most judges are just requiring that first year fee, because that's just last month in October is when they opened up the portal for us to be able to start paying those fees. So that's new. A couple of other changes that are just more mechanics of what happens in court. It's that the government is not talking to us anymore. So it used to be that we could go to OPLA, which is the Office of the Principal Legal Advisor, the prosecutors of the immigration side, and we would be able to say, hey, we've got this trial coming up. You've seen all the evidence. This is what we've got. Can we agree on 80% of the case so that we can only focus in on maybe the 20% that we don't agree? So maybe we agree that there's been harm, that the harm has been severe enough that it counts as persecution. Maybe all we want to discuss is, can this person reasonably go back to China, right? Is it reasonable to have them relocate in China, right? Sometimes you had cases where the government would allow you to negotiate on those things, and then you can hone down when you go to trial. This is not happening anymore, which means that if you are going to an asylum individual hearing or a trial, you have to prepare everything in your case. And that also means the client has to be ready to testify about absolutely everything in their case. So that's more difficult. Sometimes we could concentrate on something and make the case easier. That also means that the OPLA is not willing to agree to grant asylum. Sometimes we would get such a good case that OPLA would say, you know what, I agree that this should be an asylum grant. We would go to court and the judge would say, we agree that this is an asylum, and it would be the easiest case to pass through, but it's because it's prepared really well and everything's there. They're not even allowed to do that anymore. They're not even really allowed to talk to us. So that is a sort of big technical change. There's evidentiary limitations. Technically, there should not be a limit to how many pages of evidence that you can submit to a judge, but there are some judges who are saying maximum 150 pages, maximum 100 pages of evidence. And that is difficult in cases where maybe you have years of persecution, maybe where you have to prove a lot of country conditions. I sometimes submit reports out of Venezuela, out of Cuba, that are hundreds of pages long. Just the one report talking about the conditions in that country and the evolution of that country. So that limits the asylum seekers' rights to due process, rights to have a fair trial. And, sometimes you have to fight the judges on that. And if they don't give you that, you can appeal because of that, because they're limiting your due process rights by limiting the evidence that you can present. That's always why you need attorneys by your side helping you fight these things, because it's unfair to say, hey, you can only submit this much evidence. It might be comfortable for them to only read that many pages, but if your case requires more, it requires more to understand. The last thing that I would say about this is there's a push from the Trump administration for judges to do more individual hearings and close more cases. So in the past, as an attorney, I've been able to ask for an 8-hour trial, a whole day with a judge for me to present a family's case. Maybe I have 5 or 6 witnesses, an expert, a medical doctor presenting evidence, plus the client's testimony. Right now, I've had trials with under 90 minutes. In 90 minutes, it is almost impossible to tell your entire life story and what happened in your country and why you deserve asylum. And so it's very, very important nowadays to make sure that your case is strongly documented, because you may not have time to speak and say everything, especially because most asylum seekers are speaking another language. So when we have a translator in the middle, that cuts our trial time in half or less. So it's very important that your case is just very well documented, because if you need to go to an appeal, the documentation is what's going to save you there. So all of these changes just make it such a difficult environment for asylum seekers, and it makes it more costly. It makes it a bigger headache to be able to have an asylum case right now.
So, how has the expansion of expedited removal affected asylum seekers at the border and those already in the United States?
Yes, so expedited removal is a tool that the United States government has. It's part of our laws, to be able to remove someone from the United States who doesn't have status, who arrives at our doors and doesn't have a visa, doesn't have permission to be here. Typically, expedited removal is designed for people who have less than 2 years in the United States. And so they're able to use that statute, that law, to remove you without seeing a judge. And so that's very difficult because a lot of people do have the time here and have started a process of applying asylum. And the government is closing down that asylum case, saying, hey, you're within these 2 years. Let's close your case out. And then we can just kick you out under expedited removal. Under that statute, if you claim that you are afraid to go back to your country, the law says that you can get a credible fear interview. And so that's basically a 1 to 2 hour interview with an asylum officer about why you are afraid to go back. Is it a valid reason? The example that I always use is, are you afraid of the giant spaghetti monster? Right? If you're afraid of that, then we can send you back to your country. We know that that's not a real thing. Or are you afraid of a genuine harm that your government can cause you when you go back? And so with the expansion of expedited removal, what we're seeing is more credible fear interviews for individuals. And if you don't pass that credible fear interview, which is a lower threshold in asylum, then the government is able to remove you right away. You do have a chance to go to a judge to review that. But a lot of people don't do that. They just say, well, I lost my credible fear interview. I'm just going back. The other thing that's sort of like problematic with credible fear interviews and giving everyone a credible fear interview is that for years, we basically made the discretionary calls. There were certain countries that we understood that there were certain things happening, like Cuba, Venezuela. They're in the middle of armed conflict. They're in the middle of these issues. So we just said, you know what? We're going to assume that this person's going to pass a credible fear interview. Let's go ahead and let them apply for asylum. We'll use the credible fear interviews, maybe for a country where there isn't a political problem right now. Maybe let's say you're coming from France, right? And you don't have a visa and you're coming through the border from France and you're saying, I'm afraid of the French government. Well, there's not really evidence that the French government is harming its people. This would be a person that maybe we don't give a chance to do an asylum claim right away. We'll give them that credible fear interview and we can kick them out quickly if we need to. So the expansion of the program really just affects the people who have valid claims. It may kick out a lot of individuals who are able to apply for asylum, are eligible, and then are just kicked out rather quickly. The other thing also is you don't really have access to an attorney at this point. So usually in a credible fear interview, you are detained. That's especially if you're coming through the border. You don't have time to call an attorney. They don't schedule you this. So basically they just show up to the jail, call you at that moment and pull you out and say, hey, we want to talk to you right now. So it's different than a hearing that's scheduled that an attorney can appear at. And so, you know, it's easier for clients to not pass it in that context.
Okay. With reduced access to counsel in many expedited removal cases, what steps can individuals take to protect their claims in these fast-moving proceedings?
So I would say if you know that you're applying for asylum, if you know that you're afraid to go back to your country, even before you come into the United States, if that's what you're trying to do, you should talk to an attorney. You can have a consultation with an attorney about what the process is like. Especially if you're, you know, on the other side of the border in Mexico, there are people who specialize in just talking to you about that so that you understand how to answer questions and what you should focus your story on. A lot of people have great asylum cases, but they don't think that they do. It's very interesting when I speak to asylum seekers. I work with a lot of Cuban clients, and some of them are like, well, nothing that horrible happened to me. And then they tell me about how they were jailed, how they were hit in the jail, yeah, but that happens to so many people. So sometimes asylum seekers, the reality that they live in is so common with everyone around them that they diminish their own claims. So talking to someone before you have to go through the process really helps, because that way you can know what to focus your story on, what to focus when you're in an interview. I think that really helps. The other thing is really trying to make sure that you see if there is, especially if you're not in the United States yet, seeing if there is another pathway besides asylum. That's something that with all of our cases we're doing. Is there another legal pathway that this person can explore? Because asylum is not, it might protect you and allow you to be here for a while, but not a lot of people get asylum granted. It's such a small percentage. So it might give you a work permit while you're here and while you're here for 5-10 years. But at the end of the day, most people want that green card. Most people want to be able to permanently stay here. What other pathways can you do? And to find that out, you need a consultation with an attorney, because we need to know, do you have a career that we can do some sort of business path? Do you have family links? Has something else happened to you? Other humanitarian paths? Are you able to invest in the United States and then get your green card through those paths? Because that also exists. So I think those would be my recommendations for people in that process.
So eligibility standards for claims based on family ties, gender-based harm, or persecution by non-state actors have shifted. Which of these categories face the greatest challenges today?
I think they all do. I think gender-based is a big one, because so the family categories, family-based asylum has always been relatively difficult. Like you're saying, I am being harmed because of my familial relationship, because I'm the spouse of this person, or because, I don't know, I'm married to Pablo Escobar, right? Like I'm being persecuted because of that. If you're in a relatively like well-known family, those cases, relatively are easy to win. Like, if you're being persecuted because you're Kardashian, right, in this country, and you go to another country, it's relatively easy to prove that because it's sort of well documented. But the gender-based harm is one that's more difficult to prove, because usually there's other reasons for the harm. So usually the gender-based harms are DV victims of domestic violence, where maybe your partner, and I can give you a good example. I had one from Honduras the other day, where her partner was a police officer in Honduras, and she was a severe victim of domestic violence. Because he was a police officer, he got away with being able to do that. And he is a state actor, right? The government wouldn't protect her. Unfortunately, the judge would not approve it, even though he's a police officer. And so I think those are going to be the harder ones to win. Right now, the persecution by a non-state actor has always also been difficult, because when it is not the government directly persecuting you, there's additional things you have to prove. And it's that the government is unwilling or unable to protect you. And so let's say that your house gets broken into, someone harms you, that this happens several times, but you go to the police and the police start an investigation, but they never find who did it, right? Even if you think you know who it is, but the police just never, they can't find who it is. The police are willing there to help you, right? So it's those private actor cases have always been a little bit difficult. I think it's going to be the gender-based cases, which are going to be more difficult to prove. But again, what I said earlier, that doesn't mean that you don't fight your case, especially if it's the only thing that you have. One thing is the policy and the current case law, and the other thing is law, right? So case law is different than the statutes, than the regulations, and then international law. asylum law is not only US law, but it is also international law. And so you can fight all those. When the current policy doesn't help you, we go and we fight with other things, right? So it's just going to be more difficult to win. When the policy's on your side and the government is agreeing with everything, then it's easier to push cases through. So it doesn't mean don't fight it. It just means it's going to be a different fight.
So, given faster timelines and increased scrutiny under expedited removal, what strategies should asylum seekers use to strengthen their documentation and overall case preparation?
So one thing is your declaration or your sworn statement is extremely important. And I always recommend that an attorney helps you review it, not that just you prepare it and an attorney looks at it, okay, but that an attorney interviews you in depth about everything that happened. Because sometimes, like I said earlier, people focus in on the wrong parts of their story. And sometimes it's cultural. So I have a lot of Venezuelan clients, for example, who when they write about their Venezuelan asylum, they focus a lot on, at that time, this person was running for mayor, and a lot of things about what was going on in the country politically, but not what was happening to them, right? And so asylum is really what was happening to you in that moment. The country conditions can talk about who was running for mayor, what the environment was like, but what was your life like on a day-to-day basis? So your declaration is extremely important. It is what the judge or the asylum officer is going to read primarily from your packet. So that is extremely important to have well written. It's also extremely important to make sure that it is written in a way that it is easy to read. So small paragraphs, not 20 pages of just back to back, because an officer is going to get bored or get lost. So small paragraphs. This is my name. This is where I was born. These are my parents. And it's sort of annoying to read that. It is very easy because you can easily kind of just check as they go through. It's also easy to reference back. Oh, in paragraph 20, you said this. So your declaration is a super important document. It's how you organize your case. It's also how you identify evidence that might be there or that might not be there. So let's say you were harmed and your arm was broken during a conflict with the police in Venezuela. Well, did you go to the doctor? Why didn't you go to the doctor? If you did, are there records? Have you tried to get them? You can make all of those explanations there in your declaration, because they're going to be the questions that the officer or the judge is going to be having. Well, if you were harmed, why isn't there a medical report? Or if there is a medical report, does this clinic still exist? Did you try and get the records? So you can do a lot of the explanations in that document. And then your witnesses, you can point out who was a witness. When this happened, my brother was there present. My brother saw that this happened, right? And so letter from your brother explaining his point of view of what he saw, or from anyone else, right? If that person is not available to testify or not available as a witness, you can also make those explanations. Well, my brother is still in Venezuela. He cannot notarize a document that says these things. These things can put him in danger, right? You can sort of answer all the questions that the officer or the judge might have preemptively before you're there in that hearing. And so that document, I think, it's the most important piece of evidence, your testimony, your declaration. Other things that are important to strengthen your case, you can use expert witnesses, like I mentioned. They will charge money for doing reports, for studying your case. And in order to get an expert witness, it really depends on what you're trying to prove. Sometimes we get a medical expert witness to show that the medical conditions that this individual suffered were grave enough. Sometimes the expert witness talks about the conditions of the country. Right now, I'm working with someone from Cuba where the expert is trying to tell the judge how the Cuban prisons beat people while they're in there. And so it's sort of the pattern and practice of what the Cuban government does to people who they detained, who they consider counter-revolutionaries. That's some of the terms that they use. So the expert witness can help your judge understand a lot. Those reports are very valuable. The other things that I would say to protect yourself if you're an asylum seeker is start looking for alternatives to asylum. So there are a number of humanitarian programs. There's VAWAs, there's trafficking visas for labor and sex trafficking and human trafficking, U visas for victims of crimes. There's family petitions. There's certain waivers that people can apply for. If you're married or you have a U.S. citizen legal permanent resident spouse, children, or even parents who can apply for you. And then there's also the sort of business route, your career, right? What you've been doing here for the last 7. Some individuals are able to leave, apply for some sort of business visa, and then come back into the United States. And so for those individuals who are eligible for that, sometimes voluntary departure is a good path. And so you have to speak to your attorney about that. It's very individually driven. It's also very much a personal family decision for a lot of individuals. I talk to some individuals that I say, hey, chances of winning this case are probably 10%. You may be able to get you 5 or 10 years more in the United States, but you're going to have to leave eventually. Like, there's no way for us to win this down the line. And then there's other individuals who I'm like, this is a super strong case. Like, you should continue fighting this. So it really, really depends so much on your individual case. I just think that asylum seekers now have to be looking at other options. That's what I would be doing, because asylum is not secure. You know, it's a family-based waiver. Those are cases that are so much more stronger than asylum. And it's not dependent on you and whether you're a good person and what you're doing here. Asylum is always dependent on your country and the status of your country at the day of your hearing. So those are things that you can't control. They already happened. Things that your government is doing, you can't control. So, you know, if you have another pathway, I would recommend that.
Thank you, Attorney Bilbao. To everyone joining us live, thank you for being part of this vital conversation. As you know, this asylum landscape is changing rapidly, and staying informed could make a real difference in someone's future. If you're tuning in for the first time, welcome. ImmigrationQuestion.com is a networking platform where immigrants and families can ask immigration-related questions for free and engage directly with licensed attorneys. Many users may also qualify for a free confidential consultation. We're also proud to share that ImmigrationQuestion.com is BBB accredited, reflecting our commitment to transparency, accountability, and public education. Attorney Bilbao, with your experience representing families at the border, how do you see platforms like ImmigrationQuestion.com helping individuals understand their rights and options in such a fast-changing environment?
Yeah, I love what you guys are doing with Immigration Question, because people need the information. There is a lot of misinformation. And the issue is that to a family member 5 years ago, when they came in, that is no longer good advice for your family members coming in now. It's a completely different immigration system. And it's always going to be like that. Immigration, the way that it is written in our laws, there is power given to the administration in power. And it's because it has to do with security. So whenever a new president comes in, be it Trump, be it someone else, they are going to change. They're going to open up some immigration pathways. They're going to close some others up. So it's always constantly evolving. It's good that there's information out there for the public so that they can ask questions. They can get real up-to-date information about what's happening, and then also connect to people who can help them in these processes.
Thank you for that valuable insight, Attorney Bilbao. Before we move into our live Q&A, there's one more question. What practical steps would you recommend us people to take right now to safeguard the cases and prepare for potential changes under expedited processing?
I'm sorry, my puppy is barking in the back in case you hear her. But it's hard to say that, you cannot protect yourself 100% from changes that this administration can do. What you can do is prepare your evidence packet, have that ready, and be ready for the day when immigration calls you for an interview. Do not avoid your interviews. A lot of people are like, well, I don't want to go to my ICE check-in, or I don't want to go to court. It's worse if you do that. It's worse if you just, ignore them, because then the government will label you as a fugitive, and then they don't have to give you benefits in the future. In all immigration benefits in the United States, there is something called discretion. And so if the government does not want to give you the benefit under that sort of catch-all, they can say, we don't want to use our discretion to give this individual benefit. So being ready is the best thing that I can say, being prepared. There's things, especially when you're working with an attorney, that we can sense could already happen in a case. I can give you a good example. I always ask my clients to make sure that they get a police clearance letter from their country when they're applying for a green card, when they're applying for any benefit. Why? Because 100% of the time the government asks for it. Not 100% of the time. But if the government requests that document and gives us 20 days to get it, it's impossible to get a document from Cuba in 20 days, even though it's the next country over. So if you have it already in this side with you, if the government does ask for that, then you have it. So being prepared, being ahead, trying to anticipate what the government might want from you. And immigrants by themselves might not know all those things. That's why it's good to have a team by your side who can guide you in those processes. And investing here in the United States, because it's really hard to try and do this by yourself with so many changes. I really don't know how some people try and do it by themselves. Usually we come across individuals who have tried, I tried this, I tried that, and then now they get an attorney, rather than from the beginning, this is a very difficult problem, let me work with an attorney directly. And it makes a big difference, the experience that they have with immigration. Same thing if they are outside of the United States. If you're outside and you're in the States, talk to an attorney. We help people come legally into the United States all the time. Right? But if you're already here, you've already made some mistakes, it's going to be harder to correct, and it's going to take longer to correct.
Thank you. If you've just joined us, we've been in an in-depth conversation with attorney Vilerka Bilbao on asylum policy changes and expedited removal proceedings under Trump administration. We are now opening our live Q&A session. This is your opportunity to ask questions directly to a licensed immigration attorney. Drop your questions in the chat and call us live on 516-703-3484, and we will take as many as possible. Okay, our first question. I'm afraid to go back to my country. Do I still get a fair chance to ask my asylum or ask for asylum under the new rule?
It really depends what we consider a fair chance. So if you are processed into expedited removal and all that you get is a credible fear interview, and you get it while you're detained, you haven't had the opportunity to speak to an attorney, you might not get the same fair chance as someone who gets a whole asylum trial, asylum hearing before a judge. What's good to understand is that almost everything in immigration law, you can appeal. So for example, if you do get that credible fear interview, which is a shorter interview, and you have your evidence, you have everything prepared, you're ready to give the testimony, and they still tell you no, you can ask for that to be reviewed by a judge. And when you go with a judge, you can go with an attorney as well. So understanding that you almost always have a chance to appeal. Now, what's really good to understand here is that in the appeals process, you cannot ever give additional evidence. So you want to have the case ready now, because now is when you can win your case. If you appeal and then you say, oh, well, I have this other document and I have this other thing, right? And I want you to look at it now. The government is not so forgiving. So have your cases prepared now. If you go to appeal, you're basically saying they made the wrong decision they treated, they didn't understand my case well, you have more chances of winning at that stage. So yeah, expedited removal, I don't think it's very fair how we're using it, but it does give at least the opportunity for people to have an interview before they're sent off to a country that they're afraid of returning.
Okay. Our next question is, if I was deported with expedited removal before and later find new evidence, can I come back and ask again?
Yes and no. So expedited removal gives you a 5-year ban that you're not supposed to return to the United States. If you have been deported with expedited removal, you have more evidence and you're back in your country, call an attorney, try and work with an attorney. There are things that you can request, including humanitarian parole, that you can request from abroad so that you can enter the United States legally. The problem with coming through the border or coming in and or overstaying your visa, for example, is now you violated an immigration law, and they are not very forgiving right now of even any minor violation. I mean, people used to be able to overstay your visa and then apply for your green card if you had a pathway. Right now, we see that some people are getting arrested at interviews for doing that. So yes, you technically could come back again. If you're within those 5 years, you 100% need an attorney. I would not be showing up to the border in Mexico seeking any type of entry if you don't have a valid status right now to come in. But it's difficult to say that just because you have new evidence that means that you should try again. It really depends on what you have and what your story is to see if you should try it again or not.
Thank you, Attorney Bilbao. Our next question, who decides to put me in expedited removal, CBP or ICE, and how can I find out?
So you find out when they've given you documentation, or there's that shows that CBP removal. Usually it's CBP who processes that either at the border or in a port of entry. Let's say if you show up to the United States and your visa is not valid and you somehow made it on the plane, it's CBP who's processing and putting that person in expedited removal. ICE can also do it. So it is an internal determination. They don't tell us why. They don't tell us. It's a policy decision that they're making. It used to be that we could call ICE, for example, with a detained client and explain, hey, this person is eligible for these things. There is still communication with ICE. So attorneys and ICE can communicate, not as much as before. And sometimes we can convince them, hey, look, this is a case that this person has been here for more than 2 years. You should not be placing them in removal proceedings. Here's the proof that they've been in school or their children have been in school or that during this year. But it is on you to be able to prove those things to them. And it's also not a guarantee. I know for a fact that there are many people who are being placed in expedited removal erroneously. I'm not sure if there's any litigation right now about that, but it's very possible that those individuals would be able to sue the United States government down the line because they were processed incorrectly and request that they be processed correctly. You have to talk to an attorney and get your FOIA records, which is your immigration records, get a copy of them to see if that's something that's even worth trying. Because the government does correct errors when they're wrong, especially when you sue them in fact. So, it's hard to say even who places you because it's such an internal thing. They don't share any of that information with us.
Okay, so our next question for today. Okay, I think that's all the questions for today. Attorney Bilbao, in the wake of the Nation Guard shooting by Afghan nation, how do you assess USCIS's decision to introduce additional national security measures?
Yes, so this is news that's literally from yesterday from USCIS, that they are implementing additional, basically vetting, and they're suspending entry and visa issuance for nationals of 19 different countries. And so basically at the beginning of the year, when the president, he already limited a lot of visa issuance of countries, either by designating them of terrorism or by saying that these are countries who are not cooperating with our deportation efforts. And then now, with the shooting of a National Guardsman in DC, there is an immediate, basically, pause. And so there are 12 countries who have a full suspension, both for immigrants and non-immigrants. So if you have a U.S. family member who's petitioning you, your cases are going to be affected. If you have a business visa, student visa, anything that you're not here to stay, but here to come in and work, or here to come in and do something. So Afghanistan, Burma, Myanmar, Chad, Republic of Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Libya, Somalia, Sudan, and Yemen. Those 12 countries have a full suspension. So we are not expecting any pending applications or new applications to be adjudicated. They're going to be paused, potentially just denied, which is problematic. If they're paused and restarted at a later time, that's not so bad. But if they're denied, then individuals might have to start from scratch their processes in some future. And then there is partial suspension. So visitor visas, student visas, other non-immigrant visas for nationals of 7 different countries. So Burundi, Cuba, Laos, Sierra Leone, Togo, Turkmenistan, and Venezuela. So all of those countries are also going to be seeing pending applications, any new applications, either potentially denied or just stalled in these extra vetting. And it's troublesome because there are ways that the United States can vet these individuals. They've done it before. I've worked with a lot of Afghan nationals who have come in after the United States has left, or the U.S. military has left Afghanistan, and have been vetted. And so all of those also old applications that have been approved, people might be here, those things might get revised. So please make sure that you're working with your attorneys to try and see how you can protect yourself, and then also trying to see if you do need to be making arrangements to go back if your visas are revoked or if your process is revoked. So, those are all conversations that you need to be having with your attorneys to make plans.
Thank you so much, Attorney Bilbao, for your clarity, depth, and expertise today. Your guidance offers asylum seekers and advocates a more straightforward path during an uncertain time. And to all our viewers, thank you for joining us today. We hope this conversation helps you stay informed, prepared, and empowered as you navigate challenges related to asylum or removal. Remember, you can always visit immigrationquestion.com to ask immigration questions for free and connect with licensed attorneys. Many users may also qualify for free confidential consultation. If you'd like to revisit today's discussion or share it with others, the full replay will be available on Spotify soon. Just search Borderless Talk by immigrationquestion.com. Join us again on Wednesday for another live session covering critical immigration topics, including asylum trends, green cards, employment visas, and compliance updates. Once again, thank you, Attorney Vilerka Bilbao, and thank you to everyone watching. Until next time, stay informed, stay prepared, and stay connected.
Thank you, Nikita. It was a great